Morning.
Are you ready, Mr. Chair?
Yep, go ahead.
Good morning, Mr. Chair. Committee members, I would like to start by saying I accept the amendments in the suggested amendments in the committee analysis, and I thank your committee staff for their fine work. Today I'm pleased to present AB 552, which seeks to keep the cost of public works projects low by requiring public agencies to specify all potential damages associated with project delays upfront in their public works projects, or contracts rather. Traditionally, public works contracts have included penalties for contractors that fail to deliver projects on time. Common penalties include liquidated damages, which have a set dollar amount that both the agency and the contractor agree to prior to signing the contract. Recently, several agencies, public agencies, have begun using penalty provisions such as consequential damages and not disclosing the amount of damages a contractor may be subject to. Therefore, they're not aware of the damages they would potentially be subject to. The uncertainty created by these undefined damages has led to situations where some projects simply cannot be underwritten by an insurance company. AB 552 restores certainty to public contracts by requiring agencies to disclose consequential damage amounts for project delays upfront before a contract is signed. Here to testify in support is Scott Governor for the Construction Employers Association. Mr. Chair.
Thank you. Your witness, please.
Mr. Chair and members, Scott Governor here on behalf of the Construction Employers Association. I think Assemblymember O'Donnell discussed it well, as did the analysis. The uncertainty associated with these contract provisions places contractors in a very tenuous position. They can't get insurance for this item, which creates tremendous amount of risk, especially for small contractors who don't have the cash reserves to absorb such risk. All we're asking for here is certainty. We think the amendment accomplishes that goal. And again, if a public agency elects to use a provision like this, simply tell us what the potential damage is so we can insure it and understand what we're getting into. So for these reasons, we respectfully request an aye vote. Thank you.
Thank you.
Mr. Chair, members of the committee, Chris Walker on behalf of the California Association of Sheet Metal Air Conditioning Contractors, representing 600 contractors statewide. And I'd like to emphasize the discussion on small and medium-sized contractors. The impact on them is significant. Without having the certainty, we support the bill. Thank you.
Thank you. Next witness.
Thank you, Mr. Chairman. Members, Julianne Broyles here on behalf of Associated Builders and Contractors of California, also in support for the reasons stated, will help our small contractors, of which we have 1,200 here in California. Ask for an aye vote.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, questions, comments from the committee? Mr. Gallagher?
You know, I definitely get where you're trying to go with this, and I understand it. But one of the problems might be is that, you know, with consequential damages, you don't always know. I mean, that's kind of the nature of consequential damages. They come after the fact, and you may not always be able to quantify and identify everything that's going to be a consequence of a breach of contract. So from that perspective, you know, I could see the public entities side of things saying, you know, are we going to be on the hook if we don't identify something that could be at that point in time before the project's bid somewhat unforeseeable? So I mean, is there? Go ahead.
Mr. Gallagher, I think we believe that this would bring more certainty to the process, but if I could have maybe Mr. Governor speak to that.
Sure. First, in the liquidated damage provisions, which are included in every contract, you have to kind of account for those damages which you would anticipate. So if a project's late, it would be rent on a temporary facility, utilities, moving costs, finance charges, etc. Case law has found that in order to collect consequential damages, it has to be a reasonably foreseeable damage. So the bill still provides that as a matter of practice, you can still file a tort action against a contractor for consequential damages. We are not precluding that in the bill, but to go into it up front, as the analysis notes, you're creating an assumption by putting in the contract that the contractor reasonably should have known what these damages could be. And since we don't, we think that's best left up to the court. So we're not precluding anyone from filing a tort action in this situation. We just want it out of the contract so we can insure the project.
Mr. Wagner?
All right, well, I struggled with this one a little bit. the courts have, courts have been dealing with this forever. Doesn't it go back to Hadley versus Baxendale? What's I guess I'm wondering, is this not a solution looking for a problem? We did get some of the opposition from the League of Cities saying you're just burdening us, making us think about some things, as Mr. Gallagher says, that we may not be able to foresee. The courts exist to resolve those problems in a breach of contract case as well as in another case. I don't know. I guess I'm struggling with it. I mean, we were talking over here. What do we do on this one? Tell me why this is really that important. Why it's necessary. Why the courts can't handle it. I guess because they've been doing it for hundreds of years.
First, the opposition has been removed as amended. So just clarifying that point. We received a note from the League of Cities last night, Mr. Clark, saying they will not be opposing the bill going forward.
Okay. That's news.
You're right. It can be addressed in the courts. It has been for quite some time. The problem is for contractors in any business, going to court is a very costly item. The standard in contracts, and it's been this way in the AII standard contract for 25 years, has actually been a mutual waiver of consequential damages. Because these are so unknown, we believe that is the appropriate course of action as a matter of practice, so that neither side is hit with this. Certainly the courts can, but it is very costly for businesses to go to court and fight this out.
Well, let me follow up on that. All right, so the contract says consequential damages of, liquidated damages of X and consequential damages of Y. Breach contract happens. Is it automatic? You get Y? Or do you still have to prove? Those were the potential maximum consequential damages, but for various reasons, that max has not been reached. I mean, is this functioning essentially like a liquidated damages clause, or do I still get to contest that the full amount of the consequential damages were not, in fact, incurred by the plaintiff in the contract action?
If the consequential damage amount were specified in the contract, is that because the liquidated damage amount is obviously set?
It's set.
Correct.
Right. So you're now specifying under the bill the consequential damages. Is that the ceiling, or do I get to contest that in a contract action? Certainly, I can't contest liquidated damages.
The contractor could contest the consequential damage charge under the scenario, saying it was not reasonably foreseeable. The amount has no bearing on reality. As you said, the courts have all said the amount has to be reasonable in order to be enforceable. But in this instance, at least by setting an amount, even if it's an outrageous amount, the contractor will have the benefit of a surety assisting them in the process because they can insure the action. Absent putting an amount, it is entirely borne by the contractor because we cannot insure it.
Well, and this was my problem. I share your concerns with this because when it first came to us, it was literally confusing liquidated damages and consequential damages, and we were trying to separate those. And the theories behind those two sets of damages are very different. And we are now, this bill does put the consequentials more like what happens in the liquidated damages. And because of the confusion around there, I think we need to try to be very clear. So we reached out and made sure from the league and from the counties that they understood and that their contracting process is that this was not necessarily going to frustrate them. That's why they took those amendments. And if you go back to the Hadley case, primarily consequential damages are lost profits. And in the government sense, that's not what's going to happen. What we are asking is that if they're going to put that clause in there, that they then look at the potential consequence of a breach or a particular breach in a contract and say so that if there is a breach and then that has an impact on a later contract or some other circumstance down the line, that be identified to the extent it can up front. But the problem we get into is trying to, and the way the language is originally written, was then relating it at the point of the breach, that you had to then be able to establish that they were reasonable, and you don't do that. You either put it up front or you look at what the damages were and you measure it based on what you can prove for damages later, and not mix those two. So my caution here is that because the types of damages, consequential damage and special damage on one side, and liquidated damages on the other are very, very different theories. And the more we bring them together, we're going to arguably confuse the issue even more. But I think what the contractors are looking for, and in the public sector, consequential damages are a little harder to define. I think what they're asking is, tell us what those might be up front. Give us something that we can then have a little bit more certainty about. They're not necessarily disagreeing that they're going to take them. They're looking for the certainty. And that's what I struggled with on this. And I think the compromise here, I hope, addresses that and provides a balance.
Well, there's not only nothing I disagree with in what you said. I mean, I think you highlighted the problem well, but I'm not sure I've heard the answer to it yet, because consequential damages are difficult sometimes, oftentimes, to identify. So in my contract, I am bidding on a contract to do a job that says I've got potentially $1 million, to take a nice round number, in consequential damages. If I breach on day one, it's $1 million. But if I breach on the second to last day, maybe it's now not $1 million, it's only $500,000. Because it has to be identified at the time of the breach. So $1 million might be a reasonable number for a court on day one to find, but not on the second to last day of performance. And my question is, do I, as the contractor who has breached, or who has arguably breached, now get to say, wait a minute, it's not $1 million. The consequential damages, though specified at $1 million, would have been $1 million on day one, but today they're only $500,000. Do I get to make that argument in this bill, or does this function like the liquidated damages clause, where I don't think I get to make that argument if it was reasonable on day one?
We believe you get to continue to make that argument, and I guess I will note the reason why consequential damages have not been used as a matter of practice is they are taken up in tort actions. Our preference would still be they continue to be taken up in tort actions. It would not be a wise decision, and I've spoken to a number of public agencies, for them to put a consequential damage provision in their contract for the very reasons you state. But if someone wants to make an unwise decision, we are asking for certainty. The vast majority of public agencies do not use them for the very reason you said. They go to court. That is a smarter decision. Not everyone makes smart decisions. Maybe this will encourage them to make a smarter decision, but if they opt not to, at least we can ensure the incident.
Okay. Any other comments from committee members? All right. Mr. O'Donnell, you may close.
I appreciate the conversation here, Mr. Chair. I respectfully ask for your aye vote.
Thank you. And I'm still looking for a motion, and the motion is do pass as amended to appropriations. So we do have a motion and a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Chow? Chu?
Aye.
Chu, aye. Gallagher? Gallagher, aye. Garcia? Holden? Holden, aye. Mainshine? Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out. All right. We'll now move on to item number 9, AB 525. Mr. Holden.
Good morning, Mr. Chair and members. I'm presenting Assembly Bill 525 on behalf of my joint author, Speaker Atkins and Assemblymember Wilk, to modify and modernize the California Franchise Relationship Act. I would like to begin by notifying the committee that after several discussions with the opposition, we are working to address their concerns and believe that compromise is attainable. As a former small business franchise owner, I can tell you that the one-sided nature of a franchise relationship quickly becomes apparent after signing those documents. In some cases, as recent whistleblower lawsuits have exposed, some franchisors actively filed false violation reports against minority franchisees in order to take back the business. These terrible allegations are compounded by the fact that existing law does not even afford franchisees basic contract rights. Terminations. Franchisees can be terminated for good cause, a legal standard rarely used in contract law, and even if the franchisor is in the wrong, the franchisee is severely limited in the equity or damages they can recover, frequently leaving many franchisees penniless. The standard commonly used to judge noncompliance in most other contracts in California is substantial performance. And so Assembly Bill 525 mimics this standard and replaces the current good cause standard with the well-accepted substantial compliance standard for termination of the franchise. Not only does this standard have significant acceptance in California contract law outside of franchise agreements, but it has successfully been used to govern franchise relationships in other states since the early 1970s. Equity monetization. AB 525 also allows franchisees to recover the basic equity investment they have made in their business if the franchisor terminates a relationship with the franchisee. This principle was taken directly from the International Franchise Association's own statement of principles. Anytime a franchisor takes over a franchisee's business, the franchisee is entitled to any equity they have built into the business. Transfers. Assembly Bill 525 enables franchisees to sell their businesses to a qualified new owner so long as franchisor approves. Renewal. Lastly, AB 525 provides certainty to small business franchisees that they will be able to renew their franchise agreement and continue operating their business so long as they abide by the contract terms. We will continue to work to address some of the concerns highlighted by the opposition about contracts in perpetuity. However, these basic changes level the playing field between franchisors and franchisees. Each of the changes proposed are modeled after states with balanced franchise law: New Jersey, Wisconsin, Minnesota, Nebraska, and Rhode Island. Contrary to what the opposition has claimed, there are plenty of burger stands in Wisconsin, and New Jersey is still running on Dunkin' Donuts. In fact, numerous corporations are headquartered in these states which have strong franchise laws. AB 525 retains the franchisor's ability to immediately terminate any franchisee caught committing a litany of contract violations, including stealing, violating any federal, state, or local law, repeatedly ignoring franchisor requests, or failing to pay their dues. This bill is simple, straightforward, and applies basic contract law to franchise agreements. I ask for your aye vote.
Thank you. Your witnesses in support, please.
Mr. Chairman, members, Josh Pane on behalf of Slater Associates and a newly formed organization, the California Fair Franchise Association, Catherine Slater Carter. So we support this effort. We appreciated your efforts last year, Mr. Chairman, and the members who were supportive of this. And so I'll introduce Catherine Slater Carter for her support.
Good morning.
Good morning, Catherine Slater Carter. I am now a retired McDonald's franchisee, happily retired, I should add, and represent the California Fair Franchise Association. We support AB 525. I am here to speak for the franchisees who are terrified to come forward and speak. We have many who have experienced retribution from the franchisors, and there is no way for them to come and speak for fear of bankruptcy or worse. There are franchisees who have, because of persecution by franchisors, gone on to commit suicide. There are many terrible situations. So we thank Assembly Members Holden and Atkins for pushing this bill forward, and we ask for your support.
Thank you. Next witness in support, please.
Chairman Stone, Vice Chair Wagner, and members of the committee, thank you for your time, and I thank Speaker Atkins and Majority Leader Holden for their leadership on this. My name is Keith Miller. I'm a Subway franchisee with locations in Auburn and Grass Valley. And I always remind people if I wasn't here today, I'd be making sandwiches right now. So this is a day off, isn't it? I'm also chairman of the Coalition of Franchisee Associations, which is the largest franchisee organization in the country. We only represent franchise owners, and our directors are put on the CFA board by their fellow franchisees. It's the franchisees that invest and pay taxes in California. In fact, for tax purposes, most franchise companies claim no business nexus in the state. It is the franchisees that support their community, and it is the franchisees that create the jobs in California. Franchisees work hard to build a profitable business and expect if they play by the rules, they will be allowed to operate unhindered. But that is not always what happens today. This legislation is needed as franchisees are increasingly concerned that they will not be able to bear the fruits of their labor. Without these protections, all may be lost, including their life savings and source of income. Many franchisees only want to get to the point of passing their business on to their children, and in that way realize the American dream. You will hear franchising creates opportunity, which it can and often does. But do you really think these franchise companies are creating this opportunity out of the goodness of their heart? Of course not. They franchise because the asset-light model gives them the best return on their investment, and there's nothing wrong with that. They will claim they will quit franchising and open company stores, which is a hollow threat, given that most franchise companies on their own do not have the capital to build out the locations. They are basically using other people's money. Many franchise companies are publicly traded or owned by private equity firms. Not franchising locations would adversely impact their return. The opposition often claims that bills like this last year were such a threat and would destroy franchising, but let's think about that when we had a bill make it all the way to the governor's desk. 10% of franchises in the country are in California, approximately. If it was to destroy franchising as we know it, shouldn't of all these public companies had to tell their shareholders of this great risk and even potentially notify the SEC? They didn't, and in fact, chains like Dunkin' Donuts started aggressive expansion into the state during that time, all while the bill sat on the governor's desk. So what you really have is scare tactics to maintain and grow control over the franchisee's business. Action always speaks louder than words. And with this bill, every committee member probably received a statement from the International Franchise Association. They used a franchisee, Jeff Tews, claiming that they speak on behalf of 80,000 franchise locations in the state of California. Well, you can't just state that you speak on behalf of some people and make it true, and I can tell you they don't speak for myself. What is really interesting is that Mr. Tews, who spoke on their behalf, is a Bright Star franchisee in Wisconsin. Wisconsin has some of the strongest termination and renewal laws in the country under the Wisconsin dealership or fair dealership law. In it, no grantor, and I'm going to quote from the law, may terminate, cancel, fail to renew, or substantially change the competitive circumstances of a dealership without good cause. End of the quote. It requires also a 90-day notice and a 60-day cure period on any alleged default. Further in the definitions, Wisconsin law defines good cause as, and I again will quote, failure by a dealer to comply substantially, end quote. So I guess what Mr. Tews is saying as spokesperson for the IFA is that California franchisees don't deserve the same protections he receives in his own home state. AB 525 is not creating new territory, but only bringing California law up to other states like Wisconsin. What this bill is really about is protecting franchise owners in this state first, the people who invest in this state. Making sure the franchise company does not act as prosecutor, judge, jury, and executioner. Franchise owners in the state deserve basic protection rights. After all, they do own their own business. And protecting those who are doing the investing will actually give them more incentive to invest. I respectfully ask the committee for an aye vote. Invest in California by protecting those that invest in and create the jobs in the state. Thank you.
Thank you. And you have another witness?
Yes, my name is Peter Ligarius, Chairman Stone, Vice Chairman Wagner, and I'd like to thank Assemblyman Holden for carrying this bill. I'm an attorney in San Rafael. I have my own law firm. I started my practice in the late 1970s with the Federal Trade Commission and was assigned to their franchise disclosure rule. I worked there, brought the first case in the country, got very interested in franchising almost by happenstance. And I've gone into private practice, and I devote my practice to representing franchisees. These are people in every city in this great state, outside of cities, everywhere, every one of your districts. They're hardworking people. Most of them, not all of them, but most of them put their life savings in these businesses. I'd like to distinguish a franchise from employment in that regard. In employment, it's your livelihood. In franchising, it's your livelihood. But when you're a franchisee, you put up franchise fees, typically $25,000 or more, and you do a build-out. Build-outs can run into hundreds of thousands of dollars. You sign a long-term commercial lease. As I've told Keith many times, and he knows this, franchisees are all in. And when we're talking about terminations and non-renewals, Catherine, you're right. People commit suicide when they're losing their franchises. Divorces. People come into my office, they're getting divorced. They're afraid because they have a loan they've taken out for the franchise that they're going to lose their home where their kids are. This plays out one at a time, and you don't see this. But that's what we're talking about with this bill. It's important. And there's one other little point about this bill. I've read hundreds, thousands of franchise agreements. They don't get better. They're more one-sided. And here's another little tip that most lawyers just don't realize. Franchise agreements are often for 5, 10, or 20 years. They're deliberately open-ended contracts in favor of the franchisor. And when we're talking about being terminated for breach of any obligation, which is what the current statute says, there are already hundreds, but they don't stop there. It's an incomplete contract. The franchisor wants to change it. Almost every franchise has an operations manual. The contract says you must comply with the operations manual. They start changing the hours you must be open, the products you must serve, this, that, and the other things you must buy. And if you don't comply, you get a default notice, and then you face termination. And the threat from a default notice is what we're talking about. What would this bill do? This bill corrects the major flaws in this statute. It's a 35-year-old statute. It allows the franchisor to terminate for any violation of anything. In basketball, we talk about ticky-tacky fouls. You get 6 fouls before you're thrown out. And they also talk about flagrant fouls in the NBA. Sorry, I'm a Warriors fan, not a Sacramento fan for anybody up here. But the flagrant fouls are still in this statute and haven't been changed. When this statute was passed, the IFA was here, and they've got 11 items that are unchanged. If a franchisee is really doing bad behavior, like violating the health and safety codes, they can get terminated right now under this statute and as it's going to be amended. But what they shouldn't be able to do is terminate the franchisee because some of their paperwork was a day late or things of this nature that are minor breaches. That's what the statute currently says. The statute provides no rights to renewal. It uses the word renewal, but the franchisee that has all this money in this business, it's been their livelihoods, they're up to the complete whim of the franchisor as to whether they can continue with their livelihood. This statute would change this. Final thing, this statute, when it was passed, there was a California Franchisee Council. The general counsel I knew, I was a brand new lawyer at the time, Timothy Fine, came up here after the bill was amended by the IFA's suggestions, and he said, don't pass this bill. This bill doesn't protect franchisees, but it did get passed. And the final insult to the current law is there's no remedy under this statute that's worthwhile. The current statute says if the franchisor somehow violates it, and there's very little they can do to violate it, but if they do, your remedy is we're going to have to buy back your inventory. The courts have said, oh, the legislature put in this remedy, that's all you get. So if you're a Subway franchisee, Keith, and your franchisor actually breaches the current law...
I'm going to need you to wrap up.
Yeah, your remedy is they're going to buy back your bread and your cold cuts. Even though you have several $100,000 in the business, you get $1,000 worth of inventory purchased. So this bill corrects that. Thank you.
Thank you. Other witnesses in support, if you would just state your name, your affiliation, and whether or not, and your support for the bill, I'd appreciate that.
Good morning, Mr. Chairman and committee members. My name is Jazz Dillon. I'm a 7-Eleven franchisee from Los Angeles. I also represent the 7-Eleven National Coalition of Franchisee Owners Association for Government Affairs. I do support AB 525, and I urge the committee members to vote yes. Thank you.
Thank you.
Good morning, Mr. Holden and committee members. My name is Harvinder Sidhu, and I'm multiple 7-Eleven franchises in Los Angeles. And I also represent the Franchisee Owners Association of California for Government Affairs. And I ask for your support for the bill. I ask for aye. Thank you.
Thank you.
Good morning. My name is Madhusudan Sandhu, and I'm from Los Angeles, franchisee from 7-Eleven, AM/PM, and Chevron. And I would like to get your support, and I support this bill. Thank you.